They handed me the termination papers at 4:47 p.m. on a Wednesday. I read every word twice, signed 3 copies, collected my things, and walked out. At 2:13 a.m., my phone rang with an unknown number. The voice belonged to their senior counsel, and it was shaking. "Mr. Foster, please tell me you didn't actually sign those documents." I smiled in the darkness of my bedroom. "I signed exactly what you presented to me. You might want to check Section 7, subsection C. I'm Gerald Wayne Foster, 53 years old, and I'd just been fired from the best job I ever had. What they didn't know was that I'd written the very policy they'd violated when they terminated me." The termination package sat on my kitchen table at 11:30 p.m. that Wednesday night. 3 identical copies, each signed with my full legal name, Gerald Wayne Foster. Every signature line completed, every initial placed exactly where those yellow tabs indicated. I'd spent 45 minutes reading through all 28 pages of legal documentation that TechFlow Dynamics had prepared for my departure. The severance terms were mediocre, but acceptable. 18 weeks of pay, health insurance through February, standard non-compete language. What caught my attention wasn't what they'd included. It was what they'd forgotten to attach. Section 7, subsection C, buried on page 9 between clauses about intellectual property and equipment return. In cases where termination results from documented performance deficiencies, this agreement shall incorporate by reference all performance improvement plans, warning notices, and evaluative materials relevant to said deficiencies attached herein as Appendix B. I'd written that language myself 6 years ago when I'd been promoted to Vice President of Strategic Operations. Too many good people had been dismissed on vague accusations. Too many careers destroyed with no paper trail, no accountability, no recourse. So I'd built protections into the system. Protections that required documentation, evidence, due process. Protections that TechFlow's HR department had apparently forgotten existed when they decided to fire me for consistent performance deficiencies and failure to adapt to evolving operational frameworks. My phone lit up the darkness. Unknown caller. Area code 617. I let it ring 6 times before answering. Gerald Foster speaking. "Mr. Foster, this is Stephen Walsh from TechFlow Dynamics Legal Counsel." His voice carried a tremor I'd never heard before. "I apologize for the late hour, but I need to ask something urgent about the separation documents." "I'm listening, Stephen. Have you executed the non-disclosure provisions of the termination agreement?" I glanced at the papers on my table. My signature on page 22, directly above the NDA section. I signed everything TechFlow provided me exactly as your HR director specified. "Mr. Foster, there may have been a documentation error in the materials we supplied. We're prepared to offer you revised paperwork." "What sort of error?" "I'm not at liberty to discuss specifics over the phone, but if you haven't executed the agreement, we'd appreciate scheduling a meeting. I executed all documents at approximately 7:30 p.m. this evening." I scanned the completed package and transmitted it to your HR department at 7:45 p.m. "Is something wrong with your documentation?" The pause stretched long enough that I wondered if the connection had dropped. Background voices filtered through. Someone was conducting an emergency meeting at TechFlow's legal offices at 2 in the morning. "Mr. Foster?" Stephen's voice returned, tighter now. "Can you clarify what you mean by executed all documents?" "I mean, I signed the separation agreement as presented, every page initialed where indicated, every signature line completed, the full 28-page document that HR Director Margaret Parker provided during my termination meeting. And the appendices. Did you review the attached appendices?" "What appendices?" "The document I received contained no appendices, just the 28-page separation agreement." Another extended silence. I heard someone curse distinctly in the background. "Mr. Foster, the separation agreement should have included appendix materials. Specifically, performance improvement documentation attached as Appendix B. Should have, Stephen." Interesting phrasing. Because according to Section 7, subsection C of the separation agreement I signed, performance-based terminations must be accompanied by PIP documentation. Not should be, must be. Dead silence. "I count 0 appendices attached to the document I received and signed," I continued, "which means either my termination wasn't actually performance-based, in which case you need to explain why your termination letter explicitly states performance deficiencies, or my termination was performance-based, but you failed to provide mandatory documentation, rendering the separation agreement invalid." "Mr. Foster?" "Either way, Stephen, I believe we'll be seeing each other in court. I suggest you get some rest. Tomorrow's going to be exceptionally long for TechFlow's legal team." I ended the call before he could respond. My wife Jennifer had been listening from the hallway. "You planned this?" "I planned for the possibility they might terminate me without following proper procedures," I said. "I wrote those procedures specifically to prevent what happened today. Vague performance accusations with no documentation, no improvement plans, no objective metrics. What happens now? Now we wait to see if they attempt to fabricate documentation retroactively, which constitutes fraud, or claim the appendix materials aren't actually required, contradicting their written policy." Let me explain how I got to this point. Gerald Wayne Foster, age 53, bachelor's in industrial engineering from Georgia Tech, MBA from Emory, 27 years in corporate operations management, the last 14 at TechFlow Dynamics. I'd started my career at 26 after graduate school, worked my way up through 3 different companies before joining TechFlow as operations manager 14 years ago. During my tenure at TechFlow, I'd overseen 35 major operational initiatives that generated approximately $640 million in cost savings and efficiency improvements over the years. I'd restructured the supply chain division, reducing overhead by 22%. I'd implemented quality control systems that decreased defect rates by 38%. I'd built the strategic operations department from 8 people to 74 people. For all those contributions, spanning more than a decade of dedicated service, I'd been terminated at 4:47 p.m. on a Wednesday afternoon for performance deficiencies that nobody would specify. The irony wasn't lost on me. At 53, with nearly 3 decades of experience, I was supposedly unable to adapt to new frameworks designed by executives half my age. The termination meeting had been brief and uncomfortable. Margaret Parker from HR and Ryan Mitchell, the new chief operating officer who'd been hired 8 months ago. Ryan was 34 years old, had an MBA from Stanford, and had made clear from day one that he considered TechFlow's operational approach outdated and resistant to digital transformation. "Gerald, we need to discuss a serious matter regarding your performance," Ryan had begun, staring at his laptop screen rather than making eye contact. "What performance issues?" "Multiple stakeholders have raised concerns about your operational outcomes and adaptability to new frameworks. After thorough consideration, we've determined your performance doesn't meet TechFlow's evolving standards. What specific deficiencies are you referencing? The specifics are documented in your personnel file. What matters now is transition planning and knowledge transfer to ensure operational continuity. I'd like to review that documentation of alleged performance deficiencies." "That's not necessary for this discussion," Margaret had interjected quickly. "We're prepared to offer you a comprehensive separation package if you sign the agreement today. The terms are quite generous." They'd slid the document across the conference table. I'd taken 35 minutes to read it thoroughly while they sat in uncomfortable silence, Ryan checking his phone repeatedly and Margaret shuffling papers nervously. The terms were standard for someone at my level. 18 weeks of severance, extended health benefits, non-compete clauses. But what captured my attention was the termination classification buried in the legal language. Termination for cause, performance deficiency based on failure to meet operational benchmarks and adapt to organizational restructuring initiatives, and the complete absence of any attached performance documentation. I'd signed it anyway because I knew something Ryan and Margaret apparently didn't know. Their own policy required PIP documentation for performance terminations. By signing an agreement that lacked those materials, I was documenting their policy violation in real time. The next morning, Thursday at 8:15 a.m., I received an email from Stephen Walsh with the subject line, "Urgent, documentation review required." The message was formal, but I could read the panic between the lines. "Mr. Foster, following our conversation last night, TechFlow Dynamics would like to offer you the opportunity to meet and discuss revised separation documentation that addresses certain procedural oversights in the original materials. We believe revised documentation would serve both parties' interests and ensure full compliance with company policies." I forwarded the email immediately to my attorney, Barbara Quinn, who specialized in executive employment litigation and had represented numerous senior professionals in wrongful termination disputes. I'd worked with Barbara 3 years earlier when TechFlow had tried to restructure my department, so she was already familiar with the company's practices. "They're in full panic mode," Barbara said when I called her 20 minutes later. They realized they terminated you without following their own procedures, and now they want to fix it after the fact. Can they do that legally? Not really. You already executed their agreement under the terms they presented. They accepted your signature by processing your termination and benefits transition. They can't now claim the agreement was invalid simply because they made documentation errors. Either the agreement is valid as signed, meaning they violated their own policy, or the agreement is invalid, meaning your termination lacks proper foundation. So what should I do about this meeting request? Attend the meeting. Bring me with you as counsel. Let's see what they're willing to offer to make this disappear quietly. But Gerald, understand something. This could get expensive for them very quickly. Wrongful termination settlements for executives your age with your tenure typically run into 7 figures. Monday morning, Barbara and I arrived at TechFlow's headquarters at 9:55 a.m. The receptionist seemed nervous, making multiple phone calls before finally escorting us to the largest conference room on the executive floor. Stephen Walsh was waiting with 2 people I didn't recognize, a man in his 50s who introduced himself as Peter Hoffman from TechFlow's outside counsel firm, and a woman in her mid-40s who turned out to be Diana Reed, TechFlow's chief financial officer. The presence of the CFO told me everything I needed to know. This wasn't about correcting paperwork. This was about calculating financial exposure. Mr. Foster, Ms. Quinn, thank you for coming, Stephen began, his voice notably more controlled than it had been during our 2 a.m. phone conversation. I think we can resolve this situation constructively for everyone involved. We're listening, Barbara said. Peter Hoffman opened his tablet and pulled up a document. We've prepared revised separation documentation that addresses the procedural issues with the original materials. The revised agreement includes the performance improvement documentation that should have been attached to the original agreement, properly documenting the performance deficiencies that led to your termination decision. You created performance improvement plans after the termination, I said flatly. We obtained written documentation of performance concerns that had previously been communicated verbally to you during various management meetings and reviews, Peter said carefully. We're now providing them in written form as required by policy. Barbara leaned forward. Mr. Hoffman, performance improvement plans for a termination should be created and implemented before the termination decision, not fabricated afterward to justify a decision that's already been executed. Creating them retroactively to support a completed termination is not consistent with proper employment procedures or basic due process. The documentation reflects genuine concerns that were communicated to Mr. Foster prior to his termination, Peter insisted. Then why wasn't it documented at the time? Barbara asked. Why wasn't it attached to the original separation agreement as explicitly required by TechFlow's own policy section 7C that Mr. Foster himself wrote? There was an administrative oversight in the documentation compilation process, an oversight that happened to benefit TechFlow by allowing them to terminate Mr. Foster without providing required documentation. How convenient. Diana Reed spoke for the first time, her voice taking on the tone of someone trying to control a budget crisis. Mr. Foster, perhaps we can approach this differently. TechFlow recognizes there were procedural irregularities in your separation process. We're prepared to offer enhanced severance terms as a gesture of goodwill. 28 weeks of severance instead of 18, extended benefits continuation for 24 months, and a mutual agreement not to pursue litigation in exchange for signing the revised separation agreement with the attached performance documentation. Barbara and I exchanged glances. They were essentially offering to pay me an additional 10 weeks of severance, approximately $75,000, plus extended benefits worth another $30,000 to accept documentation that should have been provided initially. What's in the performance documentation? I asked. Peter turned his tablet toward me, displaying 4 separate documents. Written statements from your direct reports and peer managers documenting specific performance concerns. I read the names. Document 1 from Carl Hudson, Director of Supply Chain Operations, claiming I had failed to meet operational efficiency targets and created bottlenecks in the modernization project. Document 2 from Patricia Stone, Senior Operations Manager, claiming I had demonstrated poor judgment during budget allocation meetings and resistance to new cost-cutting initiatives. Document 3 from Howard Clark, former VP of Manufacturing, claiming I had shown resistance to new operational methodologies. Document 4 from Ryan Mitchell himself, claiming I had consistently underperformed against key performance indicators and shown unwillingness to accept coaching feedback. I read each document carefully. They were vague, nonspecific, and critically, none included specific dates, specific incidents, specific metrics, or specific examples of the alleged deficiencies. "These documents are completely generic," I said. "Carl claims I failed to meet efficiency targets but doesn't cite a single specific target or provide any actual performance data. Patricia claims I showed poor judgment but doesn't identify which meeting, which budget decision, or what the alternative should have been. And Howard Clark," I paused, looking directly at Peter, "hasn't worked at TechFlow for 5 months. He resigned to take a position at a competitor." Peter's expression froze. "Mr. Clark left TechFlow before Ryan Mitchell even joined the company," I continued. "He couldn't possibly have observations about my performance under Ryan's leadership, which is supposedly when these performance issues became serious enough to warrant termination. You're using testimony from someone who wasn't even present during the relevant time period." Barbara was typing rapidly on her laptop. "Mr. Hoffman, using a former employee who left the company months before the alleged performance issues as a witness to those issues, significantly undermines the credibility of this documentation. A jury would have substantial questions about why TechFlow couldn't find current employees willing to provide documentation critical enough to justify termination. Mr. Clark's employment status doesn't invalidate his professional observations about Mr. Foster's performance patterns," Peter said, but his voice carried less conviction than before. "Actually, it does," Barbara said, "because it suggests TechFlow couldn't find current managers willing to provide sufficiently critical documentation to support their termination decision. So they reached out to a former employee who has no current knowledge of Mr. Foster's work to create retroactive justification." "We're not going to debate the validity of the performance documentation," Stephen interjected, trying to regain control of the meeting. "The enhanced offer is on the table. Mr. Foster needs to decide if he wants to accept it or pursue litigation that will be expensive and time-consuming for everyone involved." "We'll need time to consider your offer," Barbara said, standing. "Mr. Foster will respond within 72 hours. We left TechFlow's offices at 11:25 a.m. In Barbara's car, she turned to me with a slight smile that I'd learned meant she was about to deliver good news. "They're terrified, Gerald. Did you see how quickly they tried to move past the Howard Clark issue? They know that using a former employee who wasn't even present during the relevant time period is going to look terrible in court. So what do? We investigate. We find out how many other people TechFlow has terminated for vague performance deficiencies without proper documentation. We build a pattern and practice case showing this isn't just about you. It's about systematic policy violations. Then we take them to court." Over the next 4 weeks, Barbara's firm conducted extensive discovery. They contacted former TechFlow employees through professional networks and social media. They requested public records from state employment agencies. They reviewed court filings from other employment disputes involving TechFlow. What they found was damning beyond what I'd imagined. In the past 4 years, TechFlow had terminated 31 employees for performance deficiencies. Of those 31 terminations, 22 had been classified as requiring performance improvement documentation under company policy. Of those 22, only 5 had actually included attached PIP materials at the time of termination. The other 17 had been fired without the required documentation. Most of those people had signed separation agreements and left quietly, but 6 had hired attorneys and filed EEOC complaints alleging age discrimination. 4 had settled confidentially. 2 cases were still pending. More importantly, Barbara discovered a disturbing pattern. Nearly every performance deficiency termination had occurred within 8 months of a new executive joining TechFlow's leadership team. The new executives would identify experienced employees as resistant to change or representing legacy thinking and work with HR to manufacture performance allegations that would justify termination without having to admit it was really about cost reduction or management preference. Ryan Mitchell, the new COO who had terminated me, had done this at his previous 2 employers as well. Barbara found court records showing he'd been named in 5 wrongful termination lawsuits across his career, all alleging he'd fired experienced employees on fabricated performance accusations to make room for younger, cheaper replacements. 3 cases had settled confidentially. 2 had gone to trial, with 1 resulting in a verdict against the employer. Gerald, I think we have enough to file a comprehensive lawsuit, Barbara said during a meeting in early December. We can demonstrate that TechFlow has a systematic pattern of terminating employees for performance deficiencies without following their own policies. We can show that Ryan Mitchell specifically has a documented history of this behavior at multiple companies. And we can prove your termination violated both company policy and basic procedural fairness. What are we asking for? Reinstatement with back pay, or in the alternative, substantial damages for wrongful termination, age discrimination, and intentional infliction of emotional distress, plus attorney's fees. I'm thinking we start at $2,000 and $400,000 and see what they counter with. We filed the lawsuit on December 12th in Georgia Superior Court. The complaint alleged multiple causes of action. Breach of contract. TechFlow violated its own employment policies by terminating me for performance deficiencies without providing required PIP documentation. Wrongful termination. The performance allegations were pretextual, and the actual reason for termination was Ryan's desire to install younger managers. Age discrimination. The systematic pattern showed targeting of employees over 45 for termination, based on alleged inability to adapt to new technologies and methodologies. Violation of public policy. Using fabricated performance allegations to terminate employees violates Georgia public policy protecting workers from retaliation and false accusations. The lawsuit requested $400,000 in compensatory and punitive damages, plus reinstatement or front pay, plus attorney's fees. TechFlow's response came 3 weeks later. They filed a motion to dismiss, arguing that I had signed a separation agreement that waived all claims related to my employment and termination. Their position was that regardless of any procedural issues, I had voluntarily agreed to the terms and couldn't now claim the agreement was invalid. Barbara filed a comprehensive opposition, arguing that the separation agreement was invalid because it didn't comply with TechFlow's own policy requirements for performance terminations. Her brief laid out the legal principle that an agreement which violates the employer's own written policies designed to protect employees cannot be enforceable, especially when the policy violation was deliberate and designed to circumvent employee protections. The hearing on the motion to dismiss was scheduled for February 15th before Judge Alan Young. Both sides would present oral arguments about whether the separation agreement was valid and enforceable given the policy violations. Judge Young had a reputation for asking tough questions and not tolerating legal gamesmanship. He'd been on the bench for 22 years and had seen every employment law trick in the book. The hearing lasted 90 minutes. Peter Hoffman argued that I had signed the agreement voluntarily after taking substantial time to read it, and that any internal policy issues were irrelevant to the validity of a contract between sophisticated parties. Barbara argued that an agreement that deliberately omits documentation required by the employer's own written policies is not a valid contract, especially when the policy was specifically designed to protect employees from exactly the kind of arbitrary termination I'd experienced. Judge Young asked the critical question that would determine everything. Mr. Hoffman, if TechFlow's policy requires performance improvement documentation for performance-based terminations, and this documentation is meant to protect employees from arbitrary dismissal, why wasn't it attached to the separation agreement Mr. Foster signed? There was an administrative oversight, Your Honor. The documentation existed but wasn't properly compiled with the separation materials. If it existed at the time of termination, why wasn't it provided? And if it didn't exist at the time of termination, how can TechFlow claim the termination was properly documented according to their own standards? Peter didn't have a satisfactory answer to that question. He fumbled for several seconds before responding, Your Honor, the company maintains that proper procedures were followed, and any documentation issues were purely administrative in nature. Judge Young wasn't buying it. Mr. Hoffman, this appears to be a case where the employer created policies to protect employees from arbitrary termination, then ignored those same policies when it was convenient to do so. These questions about policy compliance and contract validity are substantial enough that they should be resolved through discovery and potentially trial, not dismissed at this preliminary stage. The ruling was exactly what we needed. Judge Young denied the motion to dismiss, stating, This case raises genuine questions about whether TechFlow followed its own employment policies and whether the separation agreement is valid when it omits documentation that the company's own policies require. These are factual and legal issues that cannot be resolved without further proceedings. That ruling changed everything. Discovery meant TechFlow would have to produce internal documents showing how they handled other performance terminations. Depositions meant Ryan Mitchell would have to testify under oath about why he fired me and whether he'd followed company policies. Trial meant a jury would hear about TechFlow's systematic pattern of firing experienced employees on vague performance allegations. Within 2 weeks of Judge Young's ruling, we received TechFlow's first serious settlement offer, $1,600,000, no admission of wrongdoing, mutual confidentiality agreement. It's a significant offer, Barbara said when we met to discuss it. About 4 years of your salary plus substantial damages, but it's also exactly 2/3 of what we asked for, which suggests they're still hoping to control their exposure. What do you recommend? I recommend we counter at $2,100,000 with limited confidentiality. If they're serious about settling, they'll come up substantially. If they're not, we continue to trial and let a jury decide what your career and reputation are worth. We countered at $2,100,000. TechFlow came back at $1,800,000. We countered at $1,150,000. They came back at $1,850,000. But then something happened that changed the entire dynamic of our case. During the discovery process, Barbara's firm subpoenaed TechFlow's internal emails and communications related to my termination. What we found in those emails revealed the deliberate and calculated nature of what had happened to me. 3 weeks before my termination, Ryan Mitchell had sent an email to Margaret Parker and Diana Reed with the subject line Q4 Cost Optimization Strategy. The email read, "We need to reduce operational overhead by $2,100,000 before year-end to hit board profitability targets. Recommend targeting senior operations staff with highest compensation packages. Gerald Foster, $175,000 base plus bonus is top of list. He's resistant to the new efficiency initiatives and represents legacy thinking that's slowing our modernization efforts." What's the cleanest termination path? Margaret had responded. Performance-based termination requires PIP documentation per policy section 7C. We don't have current PIPs for Gerald. Creating proper documentation would take 90 to 120 days minimum. Ryan's response was damning. Don't have that kind of time. Board review is in 6 weeks. Can we use past performance reviews or get managers to document recent concerns retroactively? Diana had chimed in. Legal will want something in writing to justify performance termination. Can we get written statements from his direct reports about recent performance issues? Margaret's final email in the chain was the smoking gun. I can reach out to Carl, Patricia, and Howard for written statements about performance concerns. We'll need to move quickly before Gerald has time to build any defense. Ryan's reply, perfect. Get those statements and let's execute this plan. Keep the circle tight. Don't want him getting advance warning or rallying support from other staff. That email chain proved several critical things. First, my termination wasn't about performance at all. It was about cost reduction. Ryan needed to cut $200,000 from the operational budget to meet board targets, and firing senior staff was the fastest path to those savings. Second, they knew they were supposed to have PIP documentation. Margaret explicitly mentioned the policy requirement, but instead of following proper procedures, they decided to fabricate documentation after deciding to terminate me. Third, they deliberately tried to keep the process secret and move quickly to prevent me from defending myself or building support. When Barbara showed me those emails, I felt both vindicated and disgusted. Vindicated because it proved everything I'd suspected about the real motives behind my termination. Disgusted because it showed how little TechFlow valued the careers and lives they were destroying for budget numbers. This changes everything, Barbara said. This isn't just wrongful termination anymore. This is deliberate fraud and conspiracy. They knowingly violated their own policies, then attempted to cover their tracks with fabricated documentation. We amended our complaint to include the email evidence and added claims for punitive damages and conspiracy. We increased our damages demand to $3,200,000 based on the evidence of deliberate misconduct. That's when TechFlow's settlement offers got serious. Within 10 days of filing the amended complaint, Peter Hoffman called Barbara with a new offer, $2,750,000. They're panicking, Barbara told me. Those emails are devastating. No jury is going to side with TechFlow when they see executives openly discussing how to circumvent their own policies to fire someone for budget reasons. Should we take it? That's your decision, but I think we can get them to our full ask. Those emails show deliberate fraud. A jury could award substantially more than $2,750,000, especially with punitive damages. We countered at $3,000. TechFlow came back at $2,850,000. We held firm at $3,000. After 3 days of back-and-forth negotiations, they accepted. The final settlement signed in June included several components that made it particularly satisfying. $3,000 payment to me. Written admission by TechFlow that my termination did not follow proper company procedures and should not have been classified as performance-based. No confidentiality clause whatsoever. I could discuss everything, including settlement terms and the email evidence. Most importantly, TechFlow agreed to revise their cost reduction policies to explicitly prohibit using terminations as a primary mechanism for meeting budget targets. They also agreed to implement mandatory training for all executives on employment law compliance and proper termination procedures. The written admission was crucial. Most settlements include no admission of wrongdoing, but the email evidence was so damaging that TechFlow agreed to admit they'd violated their own procedures. That admission meant other TechFlow employees who'd been terminated under similar circumstances could use it as evidence in their own cases. Within 4 months of our settlement becoming public, 8 more former TechFlow employees filed lawsuits alleging wrongful termination with improper documentation. All 8 cases referenced the written admission TechFlow had made in my settlement. All 8 cases settled within 6 months for amounts ranging from $425,000 to $1,400,000. The total cost to TechFlow of Ryan Mitchell's cost reduction strategy was approximately $14,300,000 in settlements, plus legal fees, plus the cost of restructuring their HR department, plus Ryan's eventual resignation, plus the reputational damage of having multiple wrongful termination lawsuits become public, all to save $2,100,000 in operational overhead. 6 months after the settlement, I received a call from Roger Allen, who'd been on TechFlow's board during my termination. "Gerald, I wanted you to know that the board conducted a comprehensive review of our employment practices. We found systematic violations affecting 23 employees over 4 years. We've established a remediation fund totaling $6,400,000 to compensate affected employees. Your case forced us to confront problems we didn't even know existed." Today, at 54, I run a successful consulting practice specializing in employment policy compliance and organizational restructuring. My experience at TechFlow became a case study that I use in presentations to corporate boards about the real costs of ignoring your own policies. The lesson isn't just about reading your employment agreement carefully, though that's important. The lesson is that policies exist to protect everyone, employees from arbitrary treatment, and companies from the massive costs that come with policy violations. When I wrote that performance improvement documentation requirement 6 years before my termination, I was protecting future employees, including myself, from exactly what Ryan tried to do. By the time TechFlow realized their oversight in not following that policy, it was too late. That oversight ultimately cost them over $14 million. Those 45 minutes I spent reading my separation agreement carefully were the most valuable time I ever spent with a legal document. Sometimes the best revenge isn't getting even. It's using the system's own rules to expose how broken it really is.